Okay,
All right,
we're being recorded.
We got one other person who figured out how to get in.
yes, I just saw the email. I'm trying to get my camera to work here.
Great.
Sorry about that. I don't know. The camera worked yesterday, so I don't know why it's not working now. And it worked on our previous LawyeRS call.
John, why don't you give your remarks?
Okay, sure. Well, I mean, I actually retired at the end of 2019. Thank God. It was a good time to get out. I will say, I'll tell three quick things. One, I was doing a little bit of consulting work for Conrail, who I've worked for many, many years. And actually the two, I guess, interesting COVID related things is we actually had a Seventh Circuit case we were preparing for. So we actually conducted a moot court to prepare, you know, the folks who were arguing on behalf of Conrail on a WebEx. And then, you know, I was able to sort of dial into the Seventh Circuit. They have their own YouTube channel, though they weren't showing visually the three-judge panel that heard the argument. So I was able to listen in and hear all of that. And then I also had the last case I worked on, we had a summary judgment motion in front of Judge Prater here in the Eastern District. And we also did kind of a moot court, and then I listened in on the phone to the oral argument because, again, they weren't going in there. And it all seemed to go, you know, as well as can be expected. You know, the two things I've also been doing, like David and like Paul, I teach up at Temple Law School, so I've been taking a lot of Zoom and online classes and trying to get ready for my course that starts at the end of August to try to, because we're not obviously doing it in person at this point. So that's been interesting. And then the last thing is I'm a co-editor of the Temple 10Q, which is the business blog for Temple Law School. And actually, I wrote a couple of articles, you know, one on, you know, what all the legal issues were that this has created, you know, for any entity, and kind of a checklist of everything people should be getting. That I wrote that like literally the week of the lockdown, because I just was still on automatic kind of an automatic alert, feeling like I was still working even though I wasn't. And then the other article I wrote, which I thought was interesting, is every law firm, I'm sure we've all seen it, has created a COVID resources task force, you know, which is a really interesting marketing tool. And I wrote a little article about how you could actually see a legal market being formed in real time as all the law firms were vying from different positions and different sides of big issues that are going to get litigated for years. For example, does your property insurance cover business interruption when you're shut down by a virus? And you could see the law firms who were policyholders, represented versus people who represented insurers, putting articles out there, clearly trying to, you know, establish a market in real time for this stuff. And there's a whole bunch of different areas like that. So it's been kind of fun watching, you know, a little bit from a distance to see how this is affecting, you know, the legal market. Anyway, I've kept busy.
Andrea, and is Lee with us? I saw him a minute ago.
Comes and goes. As most of you know, I'm an employment attorney, and I've been super busy. My practice of law has not changed at all, and how I do my work, except I don't get to work with my clients face to face. It's in person, it's over Zoom or something. The interesting thing for me is that the legal landscape around employment law changes about every 2 to 3 weeks. About every 2 to 3 weeks, something else happens. There's a new complication with COVID, or there's new information from CDC, or something happens and things change. And so it's like turmoil all over again. And it's as a solo practitioner, it takes an enormous amount of my time just to stay up on all the information. So I spend a lot of my time doing that as well. Right now, I'm seeing, you know, Fred described it as cabin fever. What I'm seeing in employment is employment relationships beginning to fray at the edges. And by that, I mean marginal performers who were able to stay in there because they could walk down the hall and get some help. They're not getting that help anymore. people who are bosses who tend to be a little micromanager. Well, they are super micromanagers over a remote workforce. They really pound. And sometimes people at 11 o'clock midnight at night just go off wacko and write a crazy email that ends up getting them fired or causes a discrimination harassment complaint or something. So yeah, all of us many of us in our who are thought workers, we perhaps can work like this for a long, long time, but that isn't the way most people work. Most people want to be with other people when they work, and most people are more productive. They're definitely more creative when they work with other people. So I could go on for hours, but we're here to hear Paul, not me.
Thanks, Andrea. That was interesting.
John Dunce, you seem to be muted. Can you? Okay.
I was trying to see if I could get my iPhone to do it, but I can put that aside for a second. I'm sorry, I still can't get my video working, so I apologize for that. I'm not sure what the issue is. I guess are you asking?
Well, just any comments you have about how your practice is going or unusual occurrences because of the pandemic, whatever.
Yes, actually, thank you. So I'm a patent attorney. This is, I guess, my third LawyeRS meeting. The first one was in person about impeachment, which was great. And then the next one was a virtual meeting, which worked well. I obtained patents from the patent office on behalf of inventors, and we had already been set up starting about 3 or 4 years ago to have everything on our servers, and we could work from home. Previously, and I had only done it 1 or 2 times a month, but starting in March, before the city shutdown order, about 5 days before that, we started going virtual all the time. And for me personally, it's been fairly seamless because everything I need has been on the server. People are already used to interacting virtually for the most part. I have enough experience, thankfully, that I wasn't relying on other people too much to check my work, only in isolated incidences. And the patent office itself is all electronic with filings. The patent examiners are used to doing that. They've actually switched to a hoteling model where they used to work in Alexandria, Virginia, but now they can work from anywhere across the country. So for me, professionally, it's been fine. It's been hard on the children. I have a 10-year-old and a 5-year-old. The 10-year-old up with friends, kind of on the phone or on the computer. It's been a lot harder than the 5-year-old. But so I've been, kind of exercising, running, and biking when I can. My wife and I try to keep our mental health intact, but it's trying, but it could be a lot worse. So.
There's somebody on the phone ending 2128. Is that you, Paul?
It is. I'm sorry, Carl. I have a problem with my microphone in the computer, so I've had to call in. My last dozen or so Zoom meetings have been on the phone. So
Some people say that works better, actually, to use your cell phone for the audio.
It's my only option right now. So.
All right. Well, I'm the last one then, I guess. I'm retired and I can do it from anywhere. So my dear wife and I are hanging out at the Jersey Shore in our home there. And it's been very, very pleasant. How we got here, I'll just take a minute. I think this Rhoda Sholem views itself as a house of prayer, study, service, community service, and companionship. And it has a wide variety of programs. I think the strength of the congregation is in its constituent groups and its affinity groups, bringing together people with a common interest. It occurred to me about a year ago that we have an awful lot of lawyers in the congregation. Pardon me. And it might be a great idea Losing my voice. Pardon me. It might be a great idea to have a lawyers group. So I called up Fred Strober and John Broder and asked if they would be interested. They were. Fred said he was thinking about it since he was the president of having a lawyers group. The three of us convened a bunch of people for a steering committee, and we discussed how we would move forward, and we did. And I think we got a nice traction in the first year. We had a couple of wonderful dinners. We had Lexa Edsel talk about her time with Justice Ruth Bader Ginsburg. We had another night of Supreme Court night where two of our members talked about back-to-back cases they presented, and I talked about being a law clerk. We had some Ruth Bader Ginsburg events. We had a group that went to the museum, the National Museum of American Jewish History. We went to the movie together. We saw the show. We had dinner together. We had a program on a possible clause to use for a standstill during the COVID pandemic.
That was a great program. I went to that one.
Lenny Goldberger and Reed Willis organized a group to study together the Federalist Papers. We had a couple other things beside that. We have two volunteers who will be coming to Shabbat services at the Phoenix prison. We wrote a show and used to provide service company to the inmates and the congregation at Graterford. It's the same prison. They just rebuilt it and renamed it. And that program was suspended many years ago. They reached out to us again to see if we could have volunteers, and we have two people who picked up that responsibility. So I'd say in the first year, we have a lot of good things going. And these check-in meetings will probably continue, where we just have a chance to say hello to each other, learn a little bit, make some friends, tell some war stories. And we hope to pick up more of our programming in the fall. John Broder, you're on to make it.
Right. So anyway, having said all that, why don't we get into the meat of why we're here tonight? And, just briefly as an introduction, and I'll let Paul provide a little more of his own biography. But as Carl said, we've been trying to do some topical programming as we all sit here like this. And, obviously with all of the things going on in the world with issues of racial justice, and we've got our anti-racism learning project going on that Fred mentioned, and a lot of talk about, the legal issues surrounding civil rights and police conduct, et cetera. We thought this might be an interesting topic to present to our group, and I reached out to our friend Stuart Lev, who was supposed to be here tonight, but unfortunately it looks like the communication got a little mangled. Hopefully,
I saw Stuart. I saw Stuart joined us. Maybe he's not on now, but I saw him come on from.
Oh, okay. Well, in any event, he provided me with Paul's name, and Paul and I chat a little bit about this. And in any event, Paul, I'll turn it over to Paul. I will just say, and I'll mention this. I don't know if I mentioned this to you, Paul. My daughter clerked for Judge Goldberg on the Eastern District, and was working at the time that you came in and did a big project in front of the judge, and they were also incredibly impressed with you and said, he's the guy. He's probably the top civil rights lawyer in the city at this point. You really can't go wrong with him. So I'll use that as a way to kind of hand it over to you.
Paul,
thank you very much.
We're starting a little delayed, so take as long as you'd like. We'd be happy to hear anything you have to tell us.
Thank you, Carl. And thank you for that introduction, John. I'm quite honored to be here tonight. When John reached out to me and mentioned that my good friend Stu Lev had suggested my name, I felt quite honored. I think this is And as Carl, you just described what the group has been for the last year, this is a wonderful, wonderful opportunity, I think, for me to come in and be a part of your group and listen to your conversation and how this effort to create this lawyers group has been so successful. So I'm honored to be here, and I really appreciate the opportunity. I'll talk a little bit about my background just so you have some context. I'm no legal scholar. I don't want to pretend to be at the level of David Rudofsky, for example, who would be the colleague of David over at Penn Law School. But David, I've known David for a long time, and we were both on the board of the Defender Association. I was a public defender from 1987 till 1993. I was a staff attorney. I was in their special defense unit for the last year and a half in that office, kind of their elite trial unit. I left to go into private practice in 1993 and have been doing three things since then. I've been doing criminal defense, so everything from death penalty cases back in the 90s, death penalty cases, rapes, robberies, shootings. I've tried just about every case imaginable in state court. And I also started developing a federal criminal practice, and I've had a federal criminal practice ever since. But in addition, I started doing civil rights cases. And these civil rights cases were primarily police abuse cases. They were certain prisoners' rights cases that came across. I still do some of those. I did a few employment cases, but Andrea, I wouldn't pretend to be an expert on that. I abandoned that a long time ago. And by the way, I'd love to hear more about the psychology of the COVID workplace, because I agree there's a huge shift that's going on. And the third thing I did is represented protesters pro bono. So I was an activist from the time I was a teenager here in Philadelphia, an anti-racist coalition at age 15 under Rizzo. I came from the main line. I grew up in Lower Merion, but my parents were very progressive. I was active in progressive politics here in the city as a young mainliner, transplanting myself into Philadelphia and the politics at the time. I was also an activist at the time the MOVE incident happened. And actually, many years later, after I left the Defenders, I represented the MOVE organization in their post-conviction Relief Act petition and collateral attack in federal court for almost 12 years, the MOVE 9. They hired me, and I was the only attorney ever hired by the MOVE organization to represent them in a criminal matter. Now, they had Edward Dennis in the civil case stemming from the 1985 bombing, but I represented them all the way through the Third Circuit. And I've represented protesters, as I said, the entire time I left. So the first month I left in April of 93, when I left the Defender, I ran out to Chester County because a friend of mine said that there were mushroom workers that were trying to organize, and they were all arrested and charged with riot and conspiracy because they had been picketing in front of the corporate headquarters of one of the mushroom growers. And the time, place, and manner restrictions on the First Amendment issue were all posted, but they were posted in English, not Spanish. And so they all got arrested. And I went out there and argued oral habeas corpus motions to get them out immediately, and the judge ordered them out. And then I represented them for the next year and a half pro bono. And my wife said to me, "You went into private practice, was it to lose money, to put us into debt?" And I said, no. So fortunately, I've been able to make a living since 1993 doing those things that I feel very passionate about: criminal defense, the civil rights cases, and of course, pro bono for protester cases. So with respect to the protest cases, so I was one of the key lawyers during the RNC 2000. We created a collective of lawyers that represented over 400 protesters that were charged with various offenses during that time period. We won over 95% of those cases. It took us about 2 years to clear the dockets on those cases. And fascinatingly, after that, every single city, municipality that ran a convention changed their strategy and stopped arresting protesters. Other than they arrested them, but stopped charging them criminally. They issued them citations. They diverted their cases to diversionary programs because, as you well know, all of you know, that once you arrest somebody, the full panoply of criminal procedural rights come into play. So we get discovery. And one of the things that we found out during the RNC 2000 was, in fact, that the city of Philadelphia, in conjunction with the FBI Terrorism Task Force and the state police, had infiltrated what they called the puppet space, which is a group of protesters in West Philadelphia that had arranged to build puppets and various placards for the protests. And in an effort at preventive detention, they raided it, incarcerated all of them. They had cleared out 400 beds for the protesters. They put them in jail. And then I went in that night and on consecutive nights to try to convince them while they were jail striking that they needed to give their identity so we could get the public defender's office in there to represent them and fight the cases. And eventually we did that. We spent the next 2 years doing that. But prior to that, I had represented death penalty abolitionists. I'd represented environmental activists, animal rights activists. When the Iraq War came along, Afghanistan War, I represented peace activists and anti-war activists all the way through the aughts, from 2000 on to 2011. 2011 comes along, Occupy Philadelphia happens, and I ended up being one of the key lawyers again, organizing the lawyers and representing the protesters that were arrested in 4 mass protests. We won all those cases. They were all acquittals. We then brought a lawsuit, just like we did in the RNC. We brought a lawsuit, and this will be segue into qualified immunity in a moment. We brought the lawsuit against the city for the puppet space case. We litigated that case. We settled it. We then brought the lawsuit against the city of Philadelphia for the eviction night protest arrests, where they arrested people marching through the streets after they had evicted them, which was a national effort across the country for the Occupy movement, evicted them out of the space in front of the city hall. And we eventually settled that case. I then brought FOIA requests, which I'll talk about a little bit later, Freedom of Information Act requests against the FBI, the CIA, and the NSA, because right about that time, Snowden had made his revelations about domestic spying and mass data mining. And I teach a course on surveillance at Arcadia. I teach undergraduate. I teach a course on civil rights, civil liberties, and law, and I teach a course on mass incarceration and the death penalty. All the things that I teach, I've done. So one of the things that I did in that lawsuit is I sued the FBI, the CIA, and the NSA. Interestingly enough, what I got out of the FOIA request from the FBI is that they had activated a confidential human source, which is the terminology used by the FBI for a infiltrator, and put that person into the Occupy movement to gather political intelligence. My primary bailiwick with respect to protesters is arguing that the defense of the First Amendment is the cutting edge of our democracy. It's not just the right to vote. It's also the right to have uncomfortable and confrontational speech be at the core of our ongoing dialogue in our democracy. And it's the bulwark against the police state. And I'll talk a little bit about what we experienced just a month ago and my role in representing protesters based on what happened a month ago. Fast forward out of Occupy, by the way, the CIA, the NSA, and the FBI were all sued in federal court by me to turn over that information. Judge Schiller, who I love very dearly, unfortunately called them to the carpet and forced them to disclose in camera whatever it is they were hiding, but did not disclose it. So unfortunately, I lost that case, decided not to take it to the Third Circuit because there was plenty of good precedent on FOIA issues, and I didn't want to alter those precedents with this case. Coming out of that, in 2016, again, I was one of the key lawyers organizing lawyers to represent protesters during the Democratic National Convention. What the city of Philadelphia did, interestingly enough, was they had reduced the classic state criminal charges in all protest cases: obstruction of the highway, failure to disperse, disorderly conduct. They condensed it into a city ordinance and decriminalized protesting in a very clever move, so that we wouldn't get the opportunity of full panoply of criminal procedural rights, because they're not charging anybody. They're arresting, they're gathering their political intelligence, they're taking photographs, they're getting names, they're issuing citations. That information goes to the FBI, unfortunately, another attempt to chill First Amendment rights, but they're not charging them criminally. So we fought those citations. We had a whole group of lawyers fighting those citations, and everyone we fought was dismissed. The only people charged criminally were 11 people that were charged federally. So there were 4 people that jumped the fence. Now, this became a fascinating battle that's ongoing as of today. When there's a national special security event, when the president is at a particular location, the U.S. Secret Service takes over that and nationalizes the land, federalizes it, says this is federal land. Wells Fargo Center was federal land for the purpose of the convention. They put up a security fence. Much of you have seen the security fence in Portland around the federal courthouse. That's the same thing they did during the convention, except it was a quarter mile from the convention center. 4 people jumped the fence. I represented them. I coordinated the representation of them. We got those dismissed the first night. They jumped the fence. They got arrested. They got charged federally. They were dismissed. The second night, after the first night, Commissioner Ross comes out. Police Commissioner Ross says, if you're going to jump the fence or if you're going to breach the fence, you're going to be charged federally. So that was apparently the notice that the city put on the protesters. Of course, they're not watching Channel 6 News when they're in tents outside the DNC, so there wasn't actually any notice of this. Regardless, the next night, the fence is clipped. The fence is breached. It's open. 6 protesters run through the fence, and they run into the waiting arms Philadelphia Police, Secret Service. It's all a symbolic gesture, but they get charged federally. The 7th is grabbed by a police inspector from the protest side of the fence and dragged across into this national security zone. So I step up and represent him, and he's got 3 little knives on his belt. He's a full-time paramedic, has a job up in Rhode Island, and he carries these silly little knives on his belt. And those little silly knives were ways to cut gauze and bandages and tape that he had in his bag, because he functions as a paramedic at protests as well. So they accused him of bringing weapons onto a property after he's dragged across the line into the national security zone. So the feds, and I do a lot of work with the feds, a lot of work, because I'm always, handling drug cases, security cases, RICO cases, whatever. So I know all the U.S. attorneys. So I called the U.S. attorney and I said, listen, you're going to agree to bail on this guy, right? No, he brought weapons. I said, whoa, wait a minute. So I got the videotape that from Channel 29 News that was already public source video that showed these police inspector grabbing him and taking him across the line. But that was after he was detained. I lost the detention battle in court. The judge, who was not willing to release him under these circumstances in this high-profile case, detained him. So I called the U.S. attorney up and I said, we're going to do this one of 2 ways. Either I'm going to call the press and give him the video, or you're going to have him in the dock tomorrow afternoon to be released. Look at the tape. Sure enough, I get a call back. Next morning, he'll be up in the dock. So he's up in the dock, we get him released. I say to the press, they said, how did you get him released? And I said, 6 of the people arrested, they have a legal defense. They're legally innocent of this charge because this spreading of federal power beyond any reasonable limits is unconstitutional. So they've got a legal argument. The 7th guy, he's factually innocent. He never crossed the fence. So his case was dismissed. I brought a lawsuit under Bivens, and this is my segue into qualified immunity. I brought a lawsuit under Bivens, and for those of you that know anything about Bivens, Bivens is the common law adopting of the Section 1983 statute that was passed after the Civil War during 1871, the Ku Klux Klan Acts, that allowed for the civil rights of those who were freed to protect themselves and vindicate violations of their constitutional rights in federal court. So Bivens, there has never been a federal right that equaled the 1983 action until Bivens versus 6 unknown federal agents, narcotics agents, and that was 1963. Supreme Court passes Bivens. Now it's a common law crafting of the same right that existed for plaintiffs against municipal officials. So what 1983 said, and never mentioned qualified immunity, the Section 1983, even if after its adoption later on, after it was modified, says that anyone whose rights are violated under the color of state law, that is based on official act by a municipal official, has the right to bring a cause of action. And that cause of action could be based on any of the enumerated constitutional rights that we have. So Bivens is decided in 1963, and we all know that out of the civil rights movement, we have all these phenomenal Supreme Court decisions from the late from Brown versus Board of Education all the way through to the 60s, to Loving versus Virginia in 1967. We have these tremendous Supreme Court decisions that expand and empower civil rights. And then we have a backlash. Qualified immunity is part of this backlash. So we have a backlash, not only politically, we have a backlash in legal decisions that reflect the reaction to the expansion of civil rights. And I'll use Terry versus Ohio as an example. And then we'll talk a little bit about Bivens and how it affected the case that I have right now in federal court involving that protester, and the government is arguing qualified immunity and special factors, which I'll talk about in a moment. But to give you the background, let's talk about where this all came from. So we have this phenomenal expansion of civil rights during the 60s, and it was fought for on the streets. It was fought for. And eventually, as I teach all my students, Supreme Court decisions are not those decisions from the great philosophical Plato, philosopher from on high, who says, aha, I divine this right to all of you. No, they're fought for. They're struggled for. It is the chipping away at the rock as we move forwards to a more just and equitable society. So we chip away, and there's pushback. We chip away, and there's pushback. So the fight for civil rights is never ending. Those expressions of the expansion of civil rights are a reflection of the political movements and the progressive movements of those times. So now we have a reaction. Terry versus Ohio is a perfect example of that. So I've spent my life in the courtrooms arguing Fourth Amendment cases, winning and losing, on the cutting edge of our democracy. Because it's my position that the First Amendment and the Fourth Amendment are the twin bulwarks that protect our democracy against the police state. So when I argue for a drug dealer in the Court of Common Pleas in Philadelphia, as I have for the last 34 years, almost 34 years, to protect his constitutional rights under the Fourth Amendment, I'm asking to protect all of our rights under the Fourth Amendment. And when a judge creates an exception or creates another incursion on that Fourth Amendment rights, we have what we have now, which is a tattered flag of protection with all these holes in it. The Fourth Amendment has been so shot up, and there's been so many incursions by the courts in undermining Fourth Amendment rights that we have now, as I said, this tattered flag of protection. It is not a shield any longer. It's a tattered flag. Terry versus Ohio is a perfect example. Terry versus Ohio decided in 1968 is both the springboard for protection of our rights as well as the diminution of those rights over time. Why? Because what Terry versus Ohio did something fundamentally that had not been done before in policing. And this extends all the way to Snowden. This extends to the National Security Agency. This extends to the standards that are used under FISA. This extends on every single realm in our freedom and our democracy. But it starts with Terry. Because prior to that, even though we know cops lied and they fabricated to create pretexts and probable cause in the courtroom to justify a search, until Terry in 1968, the incursion, the limitation on liberty interests was based upon past action, past crime, probable cause that a crime had been committed and that the person charged or accused was involved, was connected to that crime. Terry versus Ohio does something very different. It creates the springboard for prospective intrusion, the future crime, the criminal activity afoot. If the officer believes that there's criminal activity afoot, he can justify, if it's reasonable and based on articulable facts, the stop, and then the frisk, if there's information that emerges during that stop. The stop. So Terry versus Ohio is an officer that testifies in the courtroom and says, based on all my experience and what I observed and what I witnessed, I believe that those young men were staking out that location for a burglary. And when I approached and grabbed Terry and I grabbed his jacket and I felt a weapon, I believed that that weapon was going to be used during the course of this criminal conduct. So based on my experience, I believed, and my experience, the reasonableness of my action based on my surveillance of the suspicious activity of those young men that were basically staking out that location, I believed I had enough to conduct that stop. The Supreme Court says, aha, you're right. But they didn't do it in the vacuum. They did it in the cauldron. 1968, the death of Martin Luther King, the third summer in a row in which cities went up in the struggle for racial justice in this country. 143 cities were labeled by the national government, by the federal government, as having suffered riots. What they called riots, I called the struggle for racial justice. So this wasn't done in a vacuum. And as Justice Douglas said in his dissent, we are on the pathway to totalitarianism. So it wasn't a radical civil rights lawyer that said that. It was the harbinger of a very seasoned Supreme Court justice in dissent that warned us that the next 50 years was going to be the emergence of a very dangerous, powerful police state. And that's exactly what's happened. So over the course of my career, from the 1980s, when I left law school and began as a young public defender, all the way through the expanding war on crime, through the expansion of war on drugs and mass incarceration, witnessing it up front every day, struggling every day with these cases, what you saw was the undermining of First Amendment rights and the pretextual stories offered by police officers to lie about the circumstances to justify the seizure. Fast forward, 2011, there's a lawsuit in Philadelphia, ACLU, and my good friend David Rudofsky brings the lawsuit. And he brings it against the city of Philadelphia. And what they find out is from that lawsuit, stemming from previous litigation, which required them to record all this information, they found that out of 253,000 car stops, 72% of the people stopped were African American. And out of those 253,000 car stops, only 8% resulted in a criminal charge. There's your police state. It's the random, unfettered decision-making by the police on the street to occupy communities of color in this country, in this city, and undermine constitutional rights at will. That's a police state. It's not something we see on the main line. It's not something we see in the suburbs. It's something that African Americans and Hispanic communities have suffered throughout our entire history. And it's what I've seen up close every day in fighting the battle over the Fourth Amendment in the courtroom. Now, 2016, there's a report. There's an updated report as ordered by the federal court. What do we find out? It's 80% of the people stopped were African American. And only 9% were charged with criminal offenses. So what happens to the other 230,000 so people that get stopped? No remedy? A violation of civil rights with no remedy? Now, Terry versus Ohio. At the other end, 2009, Supreme Court dealt with a case, Arizona, and I don't have it in front of me. Arizona versus, and I can't think of it, I'm sorry, I apologize, I should have wrote it down. But 40 years later, Supreme Court is now, all the civil libertarians that were saying, hey, Terry versus Ohio is a threat, as Justice Douglas says, it's a threat to our democracy. We're on the pathway to totalitarianism. 40 years later, they're saying, please give us Terry. Just give us that little bit, because in the cases that were left, it was profile stopping. It was, we're stopping individuals based on the colors that they wear, whether it's blue for the Crips or red for the Bloods. It's because they're in a high crime neighborhood. Every single motion I've ever tried, the officer gets on the stand and says, that was a high crime neighborhood. Why? Because the courts have sanctioned that as one of the generalized factors in determining whether there's a reasonable stop. Every neighborhood's a high crime neighborhood in Philadelphia, according to the police officer on the stand. But that becomes sanctioned by the courts over and over and over again. So where does qualified immunity come into this? Well, here's the fascinating part, and I'm going to tell you a little story that harkens back to our important time in our history, because it talks about the legislative deference that the courts give when they talk about qualified immunity. So there was no qualified immunity written into Section 1983. And in fact, in 1915, the Supreme Court said in a case involving constitutional rights, the Supreme Court said, you know what? Your good faith basis, your good faith reason for doing what you did in common law doesn't apply to a constitutional violation, and they denied it. They turned it down. Now let's go back to the cauldron of the 60s. So Ray versus Pearson, 1967, I believe, or maybe a little later, Supreme Court says, we got to protect the cops. So they find a basis to protect the police officers in Mississippi who had arrested a minister who was protesting against a segregated establishment. He gets arrested, he gets charged. Supreme Court says, you know what? That state law, that Jim Crow law, those Jim Crow laws where by 1958 there were 38 states that still had them on their books enforcing them. That Jim Crow law, by the way, we could not have anticipated. That officer could not have anticipated the change in the law. And so what do we have? We have qualified immunity. And that's the first time the Supreme Court crafted qualified immunity out of the common law onto a constitutional claim. If a reasonable, well-trained officer would not have known that that his conduct would have violated the civil rights of the plaintiff, he's protected. He's protected. He's shielded by qualified immunity. Pearson versus Ray. So what that means is that the 15th Amendment didn't have any basis. The 14th Amendment doesn't have any basis for protection for African Americans. So in other words, a state Jim Crow law that existed on the books in reaction to the expansion of rights post-Civil War, as we all know during the period of Reconstruction, we had the KKK, we had Jim Crow laws emerge, we had the labor camps. So what happened? What happens is Supreme Court adopts that rationale and says, you know what? You racist police officer in Mississippi enforcing the Jim Crow law, we're going to protect you. Just like we expanded power in 68 under Terry versus Ohio, we're going to protect you. These decisions are not scholarly decisions, they're political ones. They're political ones. And I tell my students, don't forget that. Every Supreme Court decision, I shot back at my first year my first year con law professor, when he asked me to look at the scholarship, look at the thread that runs through this as the Commerce Clause is expanded, as federal power expanded. And I said, are you kidding me? It expanded because the federal government wanted to expand. It was a great rationale to adopt it, to expand federal power. So what happens? Qualified immunity. If the law is not clearly established, the officer is protected. Well, what law is not clearly established? 15th Amendment, the 14th Amendment, they were clearly established for 100 years. What was not clearly established? That the officer believed he could choose between the racist Jim Crow statute that allowed him to arrest Reverend Pearson under the Jim Crow law based on segregation, and he'd be shielded. That's what the Supreme Court said. That's the genesis of qualified immunity. So as we go through it, what happens? Qualified immunity gets its expansion in a number of important decisions. One of them is Harlow versus Fitzgerald. So Harlow is very, very important because Harlow basically says that if there's a discretionary function by a government official, they're shielded from liability, shielded from civil damages, because the constitutional, unless it's a clearly established constitutional right. And here's the trick. What's a clearly established constitutional right? Is the right to march on the street a clearly established constitutional right under the First Amendment? Is the right to live, to exist in a cell with heat and water and some functioning aspect of human life in a cell, is that a clearly established constitutional right under the Eighth Amendment? Is the right to be free from an unreasonable search and seizure such that you are dragged across the line of demarcation into the national security zone and charged with an offense? Are you then free as a Secret Service agent to put in an affidavit of probable cause before a judge, a federal judge, have that warrant signed and say in good faith, I believe these facts to be true, when there's no evidence of any investigation conducted by that officer under the Fourth Amendment? Is that a clearly established right? So following Harlow versus Fitzgerald, which for the first time said you could raise this right. Prior to that, you'd have to raise it as a defense. So if you were representing police officers, if you were representing government officials, you'd have to raise, after Pearson in 67, you'd have to raise it as a defense and plead it. So you'd plead it in your answer, you'd raise it as defense, and you present it at trial. Not Harlow. Harlow says, we're going to cut the legs out from underneath these plaintiffs. We're going to allow them to raise it in summary judgment. We're going to allow for them to raise qualified immunity and let the plaintiff prove that it's a clearly established right. Let the plaintiff prove on top of that that it was reasonable for the officer to act the way that he or she did. Now we come to Mitchell versus Forsyth. Now there's a great story behind this. So Mitchell versus Forsyth, 1985, was a decision that said the issue was whether a warrantless search, and again, this goes right to the heart of my attack on the expansion of police state power in the surveillance state, and the fact that basically we live in a society now where the government has free reign to conduct surveillance of this particular event, of our phones, of just about every communication device. It's unfettered. Following the decisions by the Congress in 2014 and 15, we are basically living under the panopticon. But that, I digress. Mitchell versus Forsyth was a plaintiff's claim against the government for having utilized electronic surveillance without a warrant. And what the Supreme Court said, and there's a fascinating twist to this story. So the Supreme Court says that the fact that there was a warrantless search, that the warrantless search at the time for national security reasons had not been clearly established by the Supreme Court, they're immune. Mitchell is immune. Immune. Can't sue him because it wasn't clearly established. So in other words, the contextual nature of the right becomes so specific that in every single case, including the one that's presently I'm litigating on behalf of that young man, that paramedic who's a protester against the Secret Service agent, if it's not identified in an individual silo, factual silo, then it's not a clearly established right. Now, courts have pushed back. So many courts have said, no, no, no. If it goes to a core constitutional claim, you could clearly anticipate it, then it's a clearly established right. And the courts have been shifting back and forth over this in protection of police state power. So, but Mitchell versus Forsyth is a fascinating case because Mitchell versus Forsyth is the generation of a claim, a civil rights claim, based on a previous decision by the Nixon administration. So if you don't know this case, I would ask all of you to take a look at it. It's United States versus United States Eastern District Court of Michigan, 1972 decision. Now, let's go back to it. 1972. We had Watergate. I think it was 72. If I'm wrong on the dates, you guys will correct me. I think I was 12 at the time. So 1972, we had Watergate. And Arthur Kanoy writes this fascinating account of this. Arthur Kanoy, many of you, if you don't know, Arthur Kanoy was a phenomenal National Lawyers Guild lawyer, had represented Julius then as Ethel Rosenberg on appeals from their death penalty case. He had represented many activists throughout his career. And I had the great fortune as an undergraduate of listening to Arthur Kanoy in a speech that he made, and the talk that he made in a very small group, and was very inspired as a young National Lawyers Guild member back then. But Arthur Kanoy writes this. He says, of the Watergate break-in, because this all stems from this original case, United States versus United States Supreme Court, the Eastern District of Michigan. The genesis of this, according to Kanoy, is as follows. Chief Justice Rehnquist, who had been in the Solicitor General's office, and many others in the Nixon administration, had crafted a theory, much like John Hughes' whacked out theory of torture during Bush's administration, crafted this theory that national security trumps the Fourth Amendment. That in cases of national security, you don't need a warrant. But that wasn't the law at the time. Katz versus United States made it clear in 1967 that there had to be a warrant, even if you're going to wiretap a phone booth. Nixon wanted to change the law. And so what he did was, in an investigation of these radical activists that had tried to bomb a university lab in Michigan, they conducted warrantless wiretaps, much like Hoover had done for years. There's fascinating history to that as well. So they present it to the defense when they're arrested. When the young men are arrested, they present it to the defense. And the defense raises, as they anticipated, a motion to suppress. And the motion to suppress is granted by the district court judge. It's affirmed by the circuit. What they wanted to do is get to the Supreme Court because they wanted a Supreme Court precedent that said national security undermines any Fourth Amendment claim when it comes to national security, and it would give us the right, the ever-expanding right, the right that had already existed, or not the right, the power that had already existed under Hoover for 40 years to wiretap whomever he wanted to. Because that's what happened. So the story of Watergate is not just a break-in. The story of Watergate is that there had been the revelation of the largest violation of Fourth Amendment rights for 40 years, that Hoover had been wiretapping for 40 years. His enemies, his political enemies, whomever he wanted to. His power brokering was based on the wiretaps. He pushed a Supreme Court justice off the Supreme Court because of it, which is another story. So Arthur Kanoy had this theory. And here's his theory. As they brought this to the Supreme Court, the case was argued. It was presented. The Nixon administration was emboldened, just like Bush had been emboldened under Hamdi and the other cases involving the right of writ of habeas corpus. They were emboldened. We're going to cut back. We're going to carve away these rights, these important constitutional rights that represent our freedoms. We're going to do it, and we're going to do it in a national security context. So Rehnquist at that point is now in the court, and so he's got to bow out because he was one of the architects originally of this theory way back when. So he bows out. He's not there. So there are 8 justices there to decide this. Arthur Kanoy's theory that on Friday afternoon, and Carl, if you were a Supreme Court law clerk, you can verify this. I can't. I don't know this. I think you mentioned earlier you were a Supreme Court clerk. Is that correct? Carl, is that right? Yes. Okay. So
yes, he was. He clerked for Justice Burton.
Okay. So So what was theorized was, Arthur Canoy theorizes that he says in his book, Rights on Trial, he says that on that Friday afternoon before the Watergate break-in on Saturday night, the law clerks issued to the clerk, they let the clerk know that the opinion's coming forward on that Monday. Somehow someone called the White House and told the White House. This is what Canoy believes. And so the burglars broke in not to put bugs in, but to take them out, because they knew the decision was going to be 8-0 in favor of the Fourth Amendment, that the national security exemption that they sought was going to be defeated 8-0, and it was. So United States versus United States District Court for the Eastern District of Michigan is a landmark decision affirming, especially in this age of surveillance, affirming the Fourth Amendment, that if you are going to wiretap, if you are going to conduct electronic surveillance, you must get a warrant. You must have probable cause for a warrant. I deal with the FBI all the time in warrants. I file motions to suppress. When the FBI gets a warrant in one of my federal cases, they have to go through a painstaking process of doing what's called there's a necessity factor, and they've got to do all these other factors before they can get a wiretap. They've got to do electronic surveillance. They got to do physical surveillance. They got to do pen registers. They use confidential sources. They do all this before they go to the court and get a warrant. They have to jump through all these hoops. And in national security cases, Nixon didn't want to do that. Defeated 8-0. Mitchell versus Forsyth was one of the plaintiffs out of that case. Years later, brought a civil case from that. So it's fascinating to look at the impact of these cases. But qualified immunity going forward has changed. And I'm going to talk about, and then I'll stop talking because I've been running my mouth. But there are two cases that I want to mention that have had a significant impact. And for those of you that do any, and I'm sure that Andrew, you've probably encountered dozens of times these cases in your practice when it comes to summary judgment. But there are two cases that are of note that are really important to mention. One is Ziegler versus Abbasi. So Ziegler versus Abbasi is, again, a Bivens action. And here's the really dangerous part of this. So the Supreme Court, since Bivens, we get it right and it's taken away. Supreme Court since Bivens has said qualified immunity will not be, Bivens will not be extended to other areas where rights have been violated. So in 1979, it was actually extended to a discrimination. And in 1980, it was extended to apply to a case of the Eighth Amendment and cruel and unusual punishment. But ever since then, the courts have been reluctant to extend it. Because why? Because there's no clearly established law, which is the prerequisite for the defense under qualified immunity. You have to show that it's clearly established. And so over and over again, defeating claims for decades now, in the Bivens context, that's the common law crafting of the 1983 action for federal officers. The federal courts have said over and over again, we're going to protect the officers. We're going to protect them. The other case that has done great damage to plaintiffs' claims is Ashcroft versus Iqbal, which are probably many of you familiar with. It's about an 11-year-old decision. And it does the same thing. You still have to have a clearly established right. You got to demonstrate that clearly established right, that the conduct by the officer was reasonable or unreasonable in light of that clearly established right in order to get beyond summary judgment, except Iqbal now applies to a motion to dismiss under 12b-6. So now they take, not only do they whittle away on the clearly established right aspect of it, not only do they whittle away on whether it's reasonable or not, they take an objective standard, now they make it subjective, essentially, but not calling it subjective. They now then say, guess what? We can move for dismissal of your action, plaintiff, at 12b-6, at a motion to dismiss, based on the pleadings. And so as a plaintiff, now you're stuck with, in fact, I had that in a case involving a person who was wrongfully identified by DEA agents as being involved in a drug rape. I had the criminal matter dismissed. I established enough evidence. I told the U.S. attorney, you want to go to trial on this or you want to dismiss it? Dismissed. I brought the civil rights action under Bivens. Federal judge grants it under Iqbal, saying, well, it's not a clearly established right in the sense that we think the officer was reasonable in his identification of my African-American client who looked nothing like his half-brother who was involved in the drug rape. Nothing like it. So I get dismissed. That's Iqbal. So on the Rule 8 pleadings issue, the issue of qualified immunity becomes even more detrimental to plaintiff's claims. Now, let me go back. And I'll finish up with this. I want to go back to my claim, my lawsuit, currently pending on behalf of that young man who was a protester in 2016 at the Democratic National Convention. So I brought 6 of them were arrested. We tried that case in front of Judge Bailson. It's a misdemeanor, so we tried it as a bench trial. And I said to the judge, look, I've got a constitutional claim on the expansion of federal power that I want you to decide pre-trial. He says, oh, no, Mr. Hetznecker, I think I'm going to decide that during trial. You're welcome to call whatever witnesses you want. So I did. I called the U.S. attorneys and put them on the stand and talked about their discretionary decisions and the decisions by the government to put the fence not 100 yards away from the Wells Fargo Center so that Bernie Sanders supporters could actually yell at the delegates and have them hear them as they walked in, but have them a quarter of a mile away where no one could hear them, which is essentially a complete undermining of First Amendment rights. And I had a great case out of Los Angeles to support it. Bailson says, no, I'm going to hear it during the trial. I'm going to meld them two together, which he has the power to do, fortunately, in a bench trial. So he did. And I have great respect for Judge Bailson, but we went back and forth over this. And the other motion I had was a motion to dismiss based on overreaching, prosecutorial overreaching. And he, of course, denied both of those. He convicted them and gave them $250 fines. But the one plaintiff whose case was dismissed, I brought the civil rights claim. I brought the Bivens action. The U.S. attorneys come in and they say, you're not going to win this. We got Iqbal in a 12B6. We got Iqbal. You don't have a claim here. Now, I've sued the police also. I sued the police inspector, and I've sued them under conspiracy claim because he handed him over to the Secret Service, and now he's in Secret Service. Now he's in federal hands, and he gets charged federally. So I charged both the police, and they're going to do this. The city's going to say, no, it's the government, and the government's going to say, no, it's the city. So I crafted a complaint that could get both of them on the hook. At least I thought I did. Anyway, 12B6. Shockingly to them, their arrogance, I said, well, let's see what happens. Judge Roof denies it. Oh, hell breaks loose. They bring in Maine Justice. These two locals of the U.S. Attorney's Office Civil Division, they get booted. Now it's Maine Justice. Now Maine Justice comes in, and I said, and so we have this hearing, and he pushes his 12B6 argument under Iqbal again. Qualified immunity judge, I don't think it's going to get beyond summary judgment. I said, let's take discovery. All I want to do is take the depositions. Let me depose these agents. Now, what they found out is what we found out during the trial of the other 6 was that the FBI had infiltrated the protesters on the other side. And guess what? So did the Secret Service, except no one wanted to say that. So the federal government is fighting like hell to prevent me from deposing their undercover Secret Service agents, because any one of them in the crowd, if they were in the area where the fence was breached, would have known that the goofball with the face mask, I say goofball because I love him dearly, my client, but he's wearing a gas mask because he has asthma and he's afraid of tear gas, with the 3 knives on his belt, that he was not ever across that fence, that he was always on the other side. So they're fighting like hell to prevent me from deposing their Secret Service agents. So they file early summary judgment, which the rules allow. And they argue no discovery is necessary because the law is clearly established. Now, here's the other thing that I want to leave you with. There's a separate argument that's developed in the case law that deals with special factors. And so if there's a special factor hesitating the court's involvement, then they should defer to the government. And we've heard this over and over again. We heard it in the surveillance cases. Every time. That's why when I argued under FOIA, there's no good faith basis to believe that any of the surveillance conducted by the government in light of the Snowden revelations comports with the Fourth Amendment, because we know it doesn't. We now have a record that it does not. So you can't give them the benefit of good faith. You can't give them that benefit in any of these national security cases. So what we have is we have special factors. So they argue special factors hesitate the courts getting involved and expanding Bivens in a case where it should not be expanded. Bivens was a Fourth Amendment case in 1963, Judge. This is a Fourth Amendment case. There's no protection under qualified immunity for an officer who makes an unlawful arrest without probable cause. Why should it apply to a federal agent? Simply because of his status as a federal agent? Because you're invoking national security and saying there are special factors that should protect against liability for a federal agent when it doesn't protect against a police officer? If a police officer stands on the corner and makes an arrest without probable cause, he's liable or she's liable under the Fourth Amendment. Why should we then give special consideration under the guise of national security? And I cite U.S. versus United States, the United States District Court for the Eastern District of Michigan, because it's still good law. It's still precedential. It still deals with precisely this issue 40 years later. So it's pending. They filed it. They said there's no reason to take discovery. It's the first time I've ever had in my career, any time ever, where the government or any municipal defendant has come in and said, Judge, you don't need to take discovery. The issues are so clear now that we should dismiss this on the pleadings because of special factors. And so what did they cite as special factors? Because the President of the United States was there. Because this was a national security special event and all this was federal land. And so my argument was, now we see it stripped to its bone, that if it's federal property, if it's federal land, it is exempt from the Fourth Amendment. That's the threat to our democracy. Thank you for having me tonight. I appreciate it.
Oh, thank you, Paul. That was great. If folks want to hang around for a few minutes, maybe we can throw a few questions or have a little discussion with Paul. Did anybody want to raise any? I know I've got a few. Andrea.
I know this is a little bit different, but is that how you would describe what's going on in Portland?
Yes. So that's a great question, Andrea. So one of the things, and in fact, I was quoted in the paper on this issue. One of the things that we have seen is that there is this idea somehow, and there's a fascinating history to this, which I can't get into tonight because it's too long. But what we have seen is this notion that when it comes to federal policing has essentially become the tip of the tank. So to speak, it's essentially saying that under any circumstances, if we believe there's a national security threat, and you can name any civil unrest consideration a national security threat. So, for example, I get a family call me and they say, "Hey, the FBI came in, they took my son's phone, they raided the house, blah blah blah, and they want to talk to him." So I call the FBI agent. I said, "What's going on?" I said, "My client's not going to speak to you. He's got a First Amendment right not to speak to you. If you have a warrant for him, you'll tell me because I'm his lawyer. Otherwise, you're not going to approach him." And I said, "What's this all about?" He says, "Well, this is a national investigation into civil unrest." So this is precisely what's happening in Portland. They've essentially labeled the area around the courthouse, and now far beyond the courthouse, because of the civil unrest, is now federalized land. They haven't declared it, but that's exactly what the power has been exercised in doing. So they're grabbing people from the street as if we're in Nazi Germany, or if we're in some totalitarian regime, if we're in Hong Kong in 2019, they're grabbing people from the street and they're taking them in and questioning them. What did the FBI do in Philadelphia? And the FBI is going to get rankled over this because I'm going to bring them into the lawsuit. Not as direct parties, but as indirect parties under the conspiracy charge. So when the civil citations in 2016 were issued and people were getting their names and their photographs were taken, that was sent off to the FBI, no doubt in my mind. This time, in June, the FBI is waiting at the police district to ask them about Antifa. Well, on what right? On what basis do they have a right to ask any of those associational questions about who they're with, or what they're organizing, or who they're, and this boogeyman of Antifa doesn't exist in an organized way in which the federal government is trying to exploit it. So what they're really doing is criminalizing protests. So they take the most extreme examples and say, aha, this is a reason for us to go into Philadelphia, into Chicago, into Los Angeles, wherever they want to, wherever Trump wants to send his federalized private police force. That's the expansion of police state power that's very, very dangerous. Because that goes, as I said, it goes right to the heart of our First Amendment right. We have a right to protest on the street. We have the right to demonstrate. We have the right to association, and no one has the right to interfere with that. So when the FBI is questioning protesters who took a day off of work or were out of work because of COVID to march on the street and ended up on 676, now they're the subject of an FBI inquisition interrogation at a police district after being falsely arrested. Now, they haven't heard from me yet, but that's a violation of First Amendment rights. So you're right, Andrea. It's a very dangerous expansion.
So how does Portland get them out? How do we keep them out?
Well, what I think Portland should have done is instead of just seeking an injunction, what Portland should have done is limited them to the area just around the federal courthouse, and that's it. And then fight the injunction in court saying they're not necessary, that we can guard the federal courthouse or we can put up barricades. But once you give the federal government the opportunity to come in and expand their power, they're not going to take it back. They've already seized it, just like they seized a quarter mile in front of the Wells Fargo Center. They're not going to push it back, and you're going to get hard-pressed to get a federal judge to do it for you. Because the federal judges are going to defer on national security issues. They're going to defer, and that's what the government is banking on in this Secret Service case. They're banking on that the federal judge will defer to them on Fourth Amendment issues as if at any national security investigation, they're experts. So we're going to defer to them. And that's what the federal courts have done over and over again. So they definitely have to go to court, but they also have to put the police on the street and limit the power of the federal government. The Portland mayor's got to say, here are my police officers. We're handling this. We're handling it in a peaceful, nonviolent fashion. We have civil affairs out here, or their equivalent of. We don't have riot police, so we're not fomenting, some more disruptive situation. But you feds, you stay out of it. But they didn't do that. And banking on the federal courts, as you know what the circuits are, Trump has put 200 circuit court judges on the bench, 200 federal district court and circuit court judges on the bench. How many are there going to defer to the executive branch when it comes to expansion of federal power? All of them. All of them. So it's got to be a pushback locally. That's my view.
How about, Paul, the civil side of those cases, the people who have been picked up blocks away, who've been beaten up, taken into vans, released? You would think they would have pretty good Bivens civil claims.
Yeah, John, great question. And it goes back to what I just said about this case. And this is why Maine Justice is involved in this case. And this is why if she denies summary judgment for them at this point, it'll be a very important decision. Because this is exactly what they refer to as special factors. Our special factors, the national security expertise of the executive branch, are the special factors that warrant hesitation by the federal court to intervene. So we don't want you to intervene here because we are the experts, not you. And what the federal courts have done over and over again is deferred, unfortunately, over and over again, deferred to the executive branch, and federal police power is expanded. So you're right. In a case like that, where a guy grabbed off the street 5 blocks, 10 blocks from the federal courthouse, and he's seized by federal agents and taken into custody, he clearly had the Bivens claim. I would argue. What I anticipate happening is they're going to argue the same special factors that they're arguing in my case as they would in that.
Got it. Other questions?
I have a question so in a number of the cases you described false accusations, I wonder if you have any experience or thoughts on the role of video going forward. I've been quite intrigued and concerned about the use of edited video, at least in the public sphere during this summer, and I'm wondering if you've seen its effects in the courtroom or adjacent to the courtroom at this point in your practice.
Great question, David. And I don't want to keep us all night, but there's a great point about this. So back when I was doing homicide cases in Philadelphia, defending people charged with homicide, one of the things that we would argue to a jury frequently when there was a confession was, where's the videotape? You walk in with a videotape camera. You can videotape this. Why are they? Because they want to control the narrative. They want to control the narrative in that black box of interrogation for the 24 hours that they have my client, thinking that they're going to get the death penalty unless they confess, thinking that other people in the family are going to be charged, all the lies that are permitted under the law. Where's the videotape? So we fought for that in that realm. And then I testified before City Council in 2010 as the National Lawyers Guild representative on police misconduct. And I said, where are the body cams? Where are the dash cams? This was 2010. And then we started to bring in body cams. And guess what, David? They turn off and on. So all of a sudden, you know what? We made the stop and my camera went off. Gee, violation of police policy, slap on the wrist. But guess what? The narrative I still control as the officer. So yes, but on the other flip side of this is the lies, the fabrication. I mean, one of the pillars of our criminal justice system has to be the credibility of the officers who take the stand. And so for years, all that our clients had was the creative cross-examination of us as the last sentinels of the Constitution, the defense attorney, in the words of Charles Ogletree, the last sentinels of the Constitution are our craft work and cross-examining to reveal the lies. And that was all we have. Now we have video. We have cameras. We have third-party cameras. We have cell phones. And so the democratization of the truth now alters the long storied fabrication. So, for example, when Mayor Kenny and Danielle Outlaw came out about 676, and I'm representing dozens and dozens of those protesters right now in a lawsuit we filed, when they came out the night after or the week after and said, by the way, we heard that there were rocks were being thrown and that a state trooper's vehicle was being jostled. So this was the reaction. Guess what? There's not one shred of evidence of any of that. And the video, not just from the New York Times, it's the video that we have. And by the way, I represent that young man who sent that video to the New York Times in his lawsuit, in our lawsuit against the city. That video, all of a sudden they backed off and they said, oh, you know what? New information came forward. Well, this is what happens in the courtroom as a practical matter. So the video, now you're talking about something else. What I think you're talking about is the splicing and dicing and the editing video. Is that what you're saying, David?
Well, I'm interested in all of it. I'm wondering if you've ever seen anybody on the police side trying to put forth what you or a client thinks is false video.
I have not seen that yet. I have not. Now I'm not saying it won't happen, but I have not seen that yet. So that's going to be something that we all have to be very vigilant about. And certainly, as I said before, the unfettered discretion of an officer to turn off and on the body cam puts us all at a great disadvantage when all they're going to get is a slap on the wrist. So if your job is on the line, just like the whole notion of a 1983 action or a Bivens action is not just to deter the conduct, it's also to compensate the person who's been victimized by that conduct. If all that's going to happen is the officer gets a slap on the wrist and that's it, they're going to continue to turn that video off. And that to me is a form of editing, obviously.
Right, right.
Anyone else want to jump in? Hey, Jonathan.
Thank you. Thank you very much for this presentation. This was great. As with a lot of issues, unfortunately, over the last 4 years, we're seeing things that we used to think were hypotheticals, we used to think were science fiction, and are now becoming reality, unfortunately. And thank you for your work on this. We're seeing, we hope things aren't going to get worse, but we've seen every intention from Trump that he's trying to make it worse. All of Homeland Security, their entire leadership is illegal under the Vacancies Act. They're barely even pretending. When you talk about pretext, basically all of their arrests and all their actions so far, not all of them, but most of them are pretext. They're talking now, he has an executive order protecting monuments. I don't know if you've seen, he is saying that not only is he going to search into cities to supposedly crack down on crime and drugs, but to protect monuments. Not necessarily just federal monuments. So say Marconi Plaza comes under attack again, and Marconi being the fascist, the anti-Jewish fascist that he was, right? Federal officers can claim jurisdiction to protect that. So I'm wondering, given the amount of work that you already have, given that Trump is going to threatens to surge into cities, if in fact he surges into Philadelphia, do you have reinforcements? I have skills in patent litigation that I haven't used in a while, but I know basic litigation. I've seen Iqbal in the context of patent litigation. I don't know if training up people at the time would be more of a hindrance or a help. I don't know if in the next 100 days there could be training for people who are interested and they could act in a reserve capacity to help if needed, something like that. I don't know if any of that's been discussed, but I just put that out there as I would be willing to put in some time. I couldn't quit my job, say, but help 100 hours, over 2 months or something like that, if that might be theoretically helpful.
Well, Jonathan, first of all, I greatly appreciate the offer from anyone that wants to fight fascism. I mean, that's the bottom line. This is what I see as fascism. I mean, we hate to use the term, because I think people they blanch because they make comparisons. So this is not Nazi Germany. I give you that. There's no question it's not Nazi Germany in the same way, but it is fascism. And there's no question that the consolidation of police state power and the expansion of the surveillance state is very threatening, not only to our constitutional rights, but to our core notion of privacy interests. They're gone. So I appreciate any offer from anyone to help and assist in all of this. So, for example, I organized the lawyers throughout, as I said, in all those events. I organized the lawyers to represent the protesters this time around as well, not just separate and apart from the civil suit. So I organized about 26 lawyers to represent the people who were charged with the criminal violations. Unfortunately, for our clients, the civil citations were dismissed. What's left are the burglary cases on the criminal side. So where a lot of us are going to represent those clients who are charged with burglary, because it's all part of the overall social unrest and the reaction to it. So there's a political aspect to it. On the civil side, looking forward, I would always benefit from a smart lawyer that can apply their skills to an area that I would need assistance on. That's a great benefit to any work that I do, because 90% of the time I'm doing it solo, or I'm doing it with a couple other people. So that offer is accepted. In the event that I need it, I would be more than willing to reach out to you. I appreciate that.
And John, I don't know if there's a way to anyone think about training in August or September for people, like a follow-up to this for people who've had, so I had criminal justice in law school. It's been 12, 13 years, 14 years, you know, to kind of prep to this to make us more useful. But
well, I'll tell you, the only thing, before John answers that, the only thing I want to say about that, so yeah, there's a lot of, you know, for practicing, this is going into my 34th year, there's a lot of just basic ground level stuff that I take for granted. What shouldn't be taken for granted by any of us is identifying the key issue. So Andrea pointed it out. Andrea hit the nail on the head. You've got this ever expansion of federal power in Portland that is so antithetical to any notion that we have what democracy should look like. And we respond to it, I think, with horror and also fascination. I think a lot of people are looking like, what's happening here? And so there's a lot of confusion. That's all I need, a smart mind and someone who identifies a danger. That's it. All the other stuff you can learn on your way. You're not going to be, you know, a criminal defense trial lawyer in a month. You're not going to be trying, death penalty cases or drug cases in federal court. But that doesn't mean that the value of your intellectual ability to identify it, given what Andrea hit the nail on the head, we all see it. And as lawyers, we should say, you know what, we got to put our hands up and stop it. We got the protesters on the street, and we got to fight the battle in the courtroom. And so we need the lawyers to do that battle in the courtroom.
Right. And I mean, what I would say, and Carl, you can talk in a minute, we have over 200 lawyers in our group, and we have talked about some pro bono opportunities in different areas. The one project we worked on a little bit, I'm sure you may know Toby Oxholm. We're working a little bit with the Pulse group.
I don't know his personal, but I know his reputation, yes.
Yeah, he's running Pulse, which is, trying to get, basically charges wiped off against, folks who've got these long-standing, over-criminalized records at this point. It may be that there could be a group of people who would be interested in helping out wherever we could.
Absolutely. In fact, 2 of the lawyers in Pulse were part of the 26-lawyer group who were representing those individuals charged with citations. So they actually organized the effort to, back in 2016, there were actually perfunctory hearings where you'd actually sit down with your client and an administrator, some bureaucrat would sit there, pull up the citation, and then you make all your constitutional arguments and get dismissed. Now it's just a letter. So the 2 lawyers from Pulse were actually crafting the letters and providing those volunteer lawyers with the opportunity to represent a client in crafting, drafting the same kind of letter in opposition to the citation until Mayor Kennedy dismissed all of them. But yeah, right. So Pulse is directly involved.
Go ahead, Carl.
In the legal context, do you think it makes any difference whether the defendant is a police officer, a law enforcement officer on one hand, or the military on the other hand? I mean, some of the people that are abusing the citizenry are not police officers. They're not law enforcement at all. They're military. No training in legal matters and policing and so forth.
It's a great point, Carl. There are some obstacles. So if you're suing the military directly, there's some immunity obstacles that are built in statutorily. But you're right. If they're functioning, for example, in my complaint that I drafted, helped draft, but I drafted the law of the complaint and I drafted the preamble on the history of it. But in the claims that I made, one was a conspiracy claim. So the conspiracy claim both goes to the conspiracy among the police officers themselves to violate Section 1983 and Fourth and First Amendment rights, but it also, I extended it to the state police without naming them, because under the 11th Amendment bar, you have to name the individual John Doe and Jane Doe officers, which you can do. I could just name them John and Jane Doe, but we haven't done that yet for other strategic reasons. And I also mentioned the National Guard. So the National Guard, which actually falls under the aegis of the mayor when he invokes the emergency ordinance and the statute that allows him to bring them in, but I named them as co-conspirators because, in fact, they were part of this military assault on both 52nd Street neighborhood, the neighborhood surrounding 52nd Street in West Philadelphia on May 31st, as well as the military assault on 676. So I've actually charged a conspiracy count in my complaint.
Hey, one other question, Paul, and I don't know if you can answer this, but it seems like there may be some appetite at the Supreme Court to revisit qualified immunity. It looks like even Clarence Thomas, of all people, under his sort of textualist version of the world, has raised the question and actually tried to get a couple cases heard, but I think there were a few that were up, but they denied cert. I don't know where Gorsuch would be because he's theoretically in the same boat on that. But do you get any sense, or just talking to folks, that they may try to revisit this in some fashion?
That's a great question, John. And we all thought they were going to do so in June, and they did not take the petition that was pending. And the interesting thing about Thomas, from what my reading is, and again, I give very little respect to what he's done over the course of his 30 some odd years, but 35, 40 years. But what he did do on this point is he raised the point that I raised earlier, which is that the common law good faith defense never applied to the constitutional courts. That was created by Ray versus Pearson in '67. But prior to that, it's not written into the statute, and it was never part of the constitutional interpretations by the Supreme Court throughout the decades. It was always, if you had a constitutional tort, we had to contend with it, because the notion of a constitutional tort on many of the claims is built in a malice or a maliciousness. And those that aren't, obviously the good faith or the crafted on good faith qualified immunity has now become universalized on all the claims. But yeah, I think Thomas is going to the history of this, because the history of this is that it wasn't built into a constitutional claim. It was always there. Good faith was always common law. It wasn't as universal, and it certainly wasn't as absolute as qualified immunity has become. So I think you raise a really important point. I don't know if it's going to happen in the future, but here's what I always say. This is what I say every time. When the movement creates enough impetus, you have guys like Roger Goodell saying, okay, take a knee. We have a cultural change because there were 27 million people marching in the streets in favor of Black Lives Matter. That's the change. So maybe that sips up to the view from on high that social change is in the works. So I don't know. It's a great question, John, but we'll see what happens in the next term or so. In fact, if they do craft it and roll back protection.
Well, maybe in the interest of time, that's a great place to leave everything on that high, hopeful note. And I want to thank everybody for joining this. And thank you so much, Paul. That was really a very dynamic and sort of inspirational thing. My daughter, unfortunately, couldn't join us because she's putting my infant granddaughter to bed, but she was basically texting me. She said, you're the person we all should have been when we were all idealistic in law school, to really fight these battles. Fred, I saw your finger.
I'm very honored to hear that. I'm very honored to hear that. Thank you for saying such kind words.
No, I was just giving a thumbs up, John. I was just giving a thumbs up, not a question. Thank you very much, Paul. That was great.
Yeah.
Really interesting.
Great. Well, thanks, everybody.
Thanks,
Good night.
Thank you.
Paul, good to see you.
Bye.